the kind of approach that's going to be taken by some of the speakers. So we've spoken lots in this conference about various victims and villains of the triple planetary crisis. This panel is focusing fairly squarely on a villain of the piece, or what is usually described as a villain of the piece, the international investment law regime, and ISDS, particularly international investor state dispute settlement. And each panelist in their own way is looking to reform some element of ISDS so that it protects human rights and the environment rather than facilitating exploitation and so on. We've got 3 papers being presented by 4 speakers. For this panel, because we only have 3 papers being presented, speakers do have up to 15 minutes. Feel free to use less time if you'd like, if you prefer to stick to 10 or so, but you do have that freedom, and then we'll have lots of time for questions afterwards. Our first speaker is online and is Mr. Ankit Malhotra. He is an associate in the chambers of Mr. Gopal Subramanian, a senior advocate and former Solicitor General of India. And his paper is entitled The Regulatory Chill of Human Rights Risk, a New ISDS Operating Model. Ankit, anytime you're ready, please take it away.
Right, thank you. Let me begin by thanking the organizers for giving me an opportunity to share my thoughts and also do so online. I know that well, at least I would have loved to be there in person, but unfortunately I'm not able to make it. I do plan to screen share and will request someone in the audience to let me know if the screen is indeed visible. Oops. Right, here we are.
Yeah, we can see that.
Perfect.
We
Perfect.
Can see, yeah.
We, at least for the consequences of what one wishes to discuss, meet at this moment when the architecture of investor-state dispute settlement, which was initially built for an era of capital flows, is colliding with the demands of a just, rapid, and human rights consistent response to climate change. The problem is no longer theoretical. A series of cases, as I will illustrate, show how ISDS can burden or deter public interest regulation. The first case in this respect is Vattenfall vs. Germany, claims which arise and discuss Germany's nuclear phase-out policies, which ended in a settlement worth billions of euros. Think about also Rockhopper versus Italy, treaty protection which prevailed against Italy's ban on offshore fossil fuel exploration. Ecuador versus Colombia, liability followed measures taken to protect fragile ecosystems. Or the Bear Creek versus Peru case, which discusses compensation, which was awarded despite serious conflict with over and within the Indigenous consultation and social licenses. These cases, all in all, illustrate the risk of regulatory chill, where states may delay, dilute, or abandon climate and human rights measures for measures of arbitral exposure. The case all is not one-sided. Philip Morris versus Uruguay is one such example. Here, the tribunal held that the tobacco control measures as a valid exercise of sovereign authority in the interest of public. Methanex versus Chemtura, where the tribunals held that non-discriminatory, good faith environmental regulation lies at the core of the state's policy and bars. At least in these 2 cases, and in the ones I suggested above, there is a clear lesson to be learned. ISDS already contains the seeds of a more balanced approach, but they remain uneven, discretionary, and textually underdeveloped. What is needed is a new operating model. It should preserve protection against arbitrary or discriminatory state conduct, but it must also neutralize regulatory chill and where states act in good faith to the Paris temperature goals and their international human rights obligations. This model that I rest my arguments on is of threefold nature. First, climate carve-outs, and necessity-based safe harbors for a bona fide Paris-aligned regulation. Secondly, investor admissibility that filters and is grounded in ESG and human rights due diligence. And thirdly, a robust institutionalized state counterclaims mechanism. The first pillar is basically a treaty level redesign. At present, tribunals must improvise climate sensitive outcomes through doctrines such as police powers, necessity, proportionality, or expectations, usually within the treaty drafted before the Paris Agreement and before climate change was widely understood as a multiplier of human rights harm. That approach is too uncertain. It invites inconsistent reasoning and leaves states exposed. The answer is to move from a more ad hoc defense to an ex ante clarity. Future treaties and where possible amendments or interpretive instruments for legacy treaties should include express carve-outs or safe harbors for measures that satisfy three culminative conditions. First, the Paris alignment. This measure must be reasonably calibrated to achieving or at least not undermining the mitigation and temperature objectives accepted under the Paris regime, including pathways directed towards 1.5 degrees Celsius and a net zero transition. Secondly, human rights consistencies. The measures must be grounded and proportionate to states' obligations to protect rights such as life, health, food, water, culture, and an adequate standard of living as recognized in international human rights law. Third, basic rule of law safeguards. The measure must be non discriminatory, adopted in good faith, and subject to review where appropriate and accompanied by reasonable procedural guarantees. If these conditions are met, the measure should be presumptively non compensable. That is important. It would relieve tribunals from stretching customary necessity or police powers doctrine beyond their natural limits. More importantly, it would instruct tribunals as a matter of treaty design to give priority to human rights consistent claims and actions where conflict arises. This can be operationalized in three ways. Treaty text should define climate measures and be beyond and inclusive of low carbon emission strategies and subnational actions. Tribunals should be directed to interpret and invest obligations in harmony. Properly framed, this turns into a regulatory chill, into a form of regulatory insurance. States know in advance that if legislation is defined in the corridors, arbitral exposure is materially reduced. Second pillar, investor admissibility and human rights or ESG due diligence. This pillar is more about fundamental asymmetry. Investors routinely challenge state regulations through treaties, but treaties rarely require investors to show comparable due diligence in this regard. The UN Guiding Principles on Business and Human Rights are mandatory due diligence legislation in several jurisdictions, and our broader ESG reporting norms all point in the same direction. Human rights and environmental risk management is not voluntary corporate charity. It is a part of responsible economic governance. ISD has not internalized that shift. I will be willing and able to discuss this more at length in the questions if there would be any. However, I know I must remain wary of time, therefore I will skip to the operative part of this, which would hold that this is especially important in sectors where social and environmental harm is predictable. Take for example fossil fuels, mining, agriculture business, forestry, infrastructure, and heavy industries. In such sectors, human rights and environmental impacts are not collateral, they are central business risks. If ISDS is to retain legitimacy, its jurisdictional architecture must reflect that commercial reality. A due diligence filter would also serve as disciplining the function before disputes arise. Investors would know that treaty access would depend not only on the conduct of the state but also on the integrity of their operational systems. The third pillar is embedding a robust state mechanism for counterclaims. This pillar is fundamentally about rebalancing. Counterclaims should cease to be exceptional and become more normal structural features of investor state adjudication. For far too long, counterclaims have been constrained by narrow treaty language, restrictive jurisdictional reasoning, and uncertainty as to the applicable law. Yet the direction of travel is far too clear. Tribunals have increasingly accepted that where treaty text is applicable, the law that needs to be is of the states, and the advancement of counterclaims based on investor misconduct, including breaches connected to environmental damage, labor standards, or human rights, should be unimpeachable. A system that hears only investor grievances while marginalizing the state's own claims arising from the same investment is structurally incomplete. New generation treaties should therefore focus the states and the express provisions that the tribunal has jurisdiction over the state's counterclaims arising out of the same investment and alleging breaches by the investor of domestic conduct and international obligations relating to environment, climate, labor, or human rights. The applicable law should be drawn broadly to include domestic statute and, if permitted, license conditions, regulatory undertakings, and relevant international obligations properly incorporated into domestic law. All in all, what this model suggests is not a free-floating idea. It is anchored in the broader development of international law. Take, for example, the advisory opinions rendered by the International Tribunal for the Law of the Sea, or the Inter-American Court on Human Rights, or the International Court of Justice, which point towards a common understanding. States owe duties of due diligence to prevent significant environmental harm, including climate harm. They must regulate private actors whose conduct threatens right to life, health, food, water, culture, and most of all, a healthy environment. They must act for present and future generations. The challenge here is to translate those principles into arbitral doctrine and procedure. Climate carve-outs give tribunals an explicit mandate to interpret investment protections in the light of these duties. Investor admissibility filters recognition that provides private actors a responsibility to respect and manage climate harms. Counterclaims make those responsibilities procedurally enforceable in the way forums such as investors seek protection. This is especially important for the global south. States most exposed to climate harms are often states that are most exposed to risks of ISDS. This is constrained in the fiscal space and the structured dependence on carbon intensive sectors. For them, regulatory chill is not abstract. It is a life choice between the risk of a multi-billion award and the risk of failing to protect their populations from heat, drought, flooding, and displacement. To conclude, I would like to share that ISDS, at least from my analysis, stands at an inflection point. It remains tied to a narrow conception of investor expectations, insulated from climate science and human rights law. It will continue to chill regulate, intensify fiscal pressure, and weaken its own legitimacy. But if states and tribunals redesign its operating model around the three pillars I have outlined, climate carve-outs and safe harbors, investor due diligence filters, and a robust state mechanism for counterclaims, ISDS can evolve and be evolved into a system that protects legitimate investment without subordinating people and the planet. That system would not immunize every state measure from challenge, nor would it remedy the form of investor misconduct. But the baseline would change. It would recognize that state's first duty is to protect its own people, and more than the people, the natural environment, and that state investment protection must operate within that legal horizon and not above that. That I once again thank the organizers for giving me an opportunity to share my thoughts and perspective. I do hope to contribute to the discussion at a later stage when the papers have been presented, and I hand the floor back to the chair. Thank you.